Welcome, everybody. We'll get started in just a minute. All right. Hi, my name is Michael. I'm part of the Guardify outreach team. Super excited to have everyone here today joining us for a great webinar. A little bit about Guardify. Guardify is a digital evidence management platform, and we work with CACs, Child Protective Services, prosecutors, advocates, law enforcement, and beyond across the country. We are honored to host today's webinar, Process of Disclosure and Expert Witness Testimony. Some quick housekeeping notes before I turn it over to our presenter. If you'd like a copy of the presentation slides today, you can access them by using the link in the chat box. Please look out for an email later this afternoon that will explain how you can complete the evaluation form and receive your certificate. Please complete that within 30 days after today. If you have any questions during the presentation, please submit them in the Q&A box rather than in the chat box or by raising your hand. We've got a large group today, so our presenter are going to wait until the end to address them. If they're unable to answer them live during our time today, we will answer them via email. I want you all to be aware of some upcoming events and exciting news. On August 21st, we are hosting another live webinar called Child Exploitation, Parental Guidance in the Digital Age. Be on the lookout for registration information. And also, if you haven't, check out our Guardify's Real Evidence podcast, joining Ashley and Myron as they explore how technology, people, and processes unite to reshape the landscape of justice and community. Today's webinar is presented by Riley Heron. Riley is a licensed clinical social worker and clinical supervisor with over 8 years of experience in forensic interviewing. She currently leads as director of programs at Kids Hub Child Advocacy Center and trains professionals statewide and nationally through the Zero Abuse Project. With that, I'll turn it over to Riley.
Thank you so much, Michael. Super excited to be here with you all today, and thank you for taking what I think is probably most of your lunch breaks to be with us. I'm excited to be here, and I love any opportunity that I get to share about forensic interviewing and expert testimony. And so we're going to dive right on in today. A little bit of extra about me that I did not share with Guardify when they asked me to do this. I also previously worked at a local rape crisis center before I moved over into the Child Advocacy Center world. So I have been working with people with lived experiences since 2010. So for quite a bit of time now, about 15 years. And so I've done court on that side, and I've done court on the side of the Child Advocacy Center and as an interviewer. And so all of the information that I'll be sharing with you all today comes from those lens of just my education background, my personal experiences, and then obviously all of the training and expertise that I've gathered along the way. And you may find that some of the information that I share today is information that you've heard before. And that's okay. I hope that you at least take one thing away that you can implement in your own practice. So we'll go ahead and get started and jump right on in. So as he said, I'm the director of programs at Kids Hub, and I always like to add this in here because when people hear director of programs of any agency, they automatically assume that I am removed from that direct service work. Let me assure you that I am not removed from the direct service work. I absolutely still actively interview. Not as much as I used to, I'll own up to that, but I still actively interview weekly and still supervise interviewers weekly. So I am in the room regularly, and I do testify in court pretty regularly. So that's where I'm kind of coming from. Before we start diving into talking about the process of disclosure specifically, I find so often that as professionals, we don't take enough time to really understand disclosure before we ever get to the process of it. And so I really wanted to stop here to talk with you guys about what is disclosure? What does that actually mean to us? And how do we view disclosure, and how does that impact how we work with children in the room, but also how we talk to other professionals and our community when we're on the stand? So looking at jury members and looking at the district attorneys and the defense attorneys and the judge and things like that. And so I wanted to get this kind of base definition out. There are a lot of definitions that you can find, a quick Google search on disclosure, but this definition really stood out to me. And I kind of highlighted some of those big words that I wanted to look at. And so when we talk about disclosure being an act, I really honed in on this piece. So when children, or and I want to be cautious not to just say children, because in the past I have worked with adults. But when people come forward with information that was once hidden or confidential or unknown, that is an act of revealing information. And I think we often forget that there is some big action behind that and a lot of feelings behind that. And I think when we take time to understand that disclosure is a human act and not just a step or a stage in what we consider a very professional process, because that's the lens that we come from, I think we can really step back and take some time to be reverent to that, um, and really consider what are our next steps when we recognize the human act behind disclosure. And so being able to slow down and allow that child, or person, if you're working with somebody other than children, allowing that person to provide that information in a way that's going to be best suited to them. And we're going to get into that. We're going to talk about the types of disclosure today. We're going to talk about stages and what that looks like in an interview. I just wanted us to have some time to really understand this piece, the disclosure piece. The other part that I always like to talk about when we get into disclosure is that it is not linear. And you guys know this. It's not linear. Disclosure is really like a roadmap. It's all over the place, right? There's, this direction that you can go with disclosure. You can go with this direction. We are called Kids Hub because we are in the hub city of our area. And we talk about all the time how there are multiple roads and routes, and ways to get to our CAC. And it's the same for disclosure. There are multiple roads and routes and ways to get to a disclosure. And even once you get to the disclosure is not your final destination. There's so much more that comes from it. And so I always like to remind my fellow professionals, it's not linear. And when I get on stand to testify about this, it's such a beautiful analogy to explain to them what that can look like. So let's talk about the two types. You guys know this. There are two types of disclosures that we really hone in on, from a research side and when we're talking about it in court, and that's accidental and purposeful. When we're looking at accidental and purposeful, I think it's super important to remember, specifically under the accidental piece, that there are so many behaviors and thoughts and feelings that come behind this, because these are children who have not intended, or people who have not intended to disclose information. They have not intended to share about their lives anything. And so I invite you to think about a time where something about you was found out that you did not intend for people to know about you. How did you feel in that moment? What were your thoughts? What did you hope actually happened with that? And I think if we can take some time to step back and think about this from the children that we're working with or the people that we're working with, when we talk about that accidental piece, recognizing that we may have children in our space or people in our space that we're working with who not only didn't intend to tell about what was happening in their lives, but also may not recognize that they've shared significant information, or that this was information that was going to be, quote unquote, a big deal, right? And then, of course, there's purposeful disclosure. And this is the disclosure where that child has made a direct disclosure about something happening to them. It may not be a full disclosure, and I think we have to give that caveat there, and we'll talk more about that as we go into testifying in court, but it may not be a full disclosure, but they've intentionally giving a piece or a nugget of information that then initiates some follow-up. So those are your two major types. And when we're talking in court, it's so important to be able to distinguish on that specific case that you're in court for. Was this child an accidental disclosure to begin with, or were they in purposeful? And that can really help us navigate with the jury. What does that look like to help them understand, like, where's this kid coming from versus where they're at now? Because the kid that we have at the very beginning is going to look very different than the kid that shows up for a trial or for a hearing, whether it's youth court or circuit court or whatever. So looking at those from those two different lenses. So then what are those stages of disclosure? Stages of disclosure, we recognize 5 major stages of disclosure. And a lot of times, some people will break this down and put active and tentative under one category. I like to break them up because they can look obviously so different. Um, I'm not telling you guys anything special or new here, but denial is going to be that active denial. They're saying, no, nothing happened. They may not acknowledge anything at all, or they may adamantly say, nothing happened. Active is obviously where they're sharing details, but remember, not sharing necessarily everything. And then your tentative, and we're going to go into that on this next slide, going into specifics on the tentative, it can be little pieces here and there to kind of gauge reactions, see how others may respond to them, what happens in my family if I say this, or what happens in my personal life if I say this. It's the testing of the waters, right? And I feel so confident that each and every one of you have had experiences just like that, where you've heard kids test that water. And so I like to hone in on tentative because it can sound so different depending on the kid that you're working with. So we'll talk about some language there. And then, of course, there's the recantation and the reaffirmation. And I think the biggest piece here for recantation and reaffirmation um, in court specifically is recognizing that a recantation doesn't mean that something didn't happen. And that children may give some information and then choose to retract that information for a variety of reasons. And we'll talk about what those variety of reasons could look like. So I felt it was important that because this was coming from a forensic interviewer lens, that we talked about what it would look like in a forensic interview, or what it could look like. These are just some common phrases that I have heard in the 8 years that I've been interviewing children. This is obviously not an exhaustive list. I am so positive that you guys have heard something similar, or even heard other statements that are not listed here. I'm hoping that you're taking some time right now to think about, what statements have I heard in my interview that would sound like one of these stages of disclosure? And so, again, these are just some common language like nothing happened in denial. Tentative, I said I wanted to hone in on that because tentative can look like empowerment, but it can also look like I forgot. It can also look like distraction. And so that's why I put a couple of extra language pieces there. And I wanted to talk about a specific case that I had under this tentative one. That sounded very much so like empowerment. And so I interviewed this young kid. I guess it was probably my second year of interviewing. So I would have said I was still a baby in interviewer terms because I'd only been interviewing for 2 years at this point. Um, and I had this little boy come in. He was about 6 or 7 years old. And I am not from Texas, but this little boy, if you would have seen him, you would have thought for sure he's from Texas. We're in Mississippi, but he had on his cowboy boots, his Wranglers, his big belt buckle. I don't know that he'd ever been to a rodeo in his life, but you would have thought it looking at him. He had his cowboy hat on, just the cutest little thing. And he comes in and he's talking about um, the allegations that had occurred. And so the allegations were some sexual abuse by the biological father's best friend. And they were out on the farm, they have cattle, and he says that the best friend touched him. And as I'm going through the process of like getting those details, those good sensory information, he then says, well, he tried to touch me, but he didn't because I shot him in the foot with my revolver, is what he said. And I recognized immediately, hey, this is a phrase that would suggest he's not actually in active disclosure yet. He's going back and forth because remember, we talked about how disclosure isn't linear. It's kind of like this weird roadmap. And I think you all know, just as well as I know, if I turn on my GPS to get me from point A to point B, sometimes my GPS throws me on a loop, right? And I end up having to make a U-turn. So I may come back to another road. And that's exactly what he did here. He was giving me the disclosure, so he was in active disclosure. And then something happened, and I won't attest to know what it was. I don't know what it was. Maybe I said something or did something that made him go back, or maybe he thought about another factor or an influence, which we'll talk about in a minute. But for whatever reason, he comes back and he heads into tentative disclosure instead of staying in that active disclosure, and says, yeah, no, for sure, he tried, but I shot him in the foot with my revolver. And at this point, as an interviewer, I had this really beautiful opportunity to recognize one, hey, that's a tentative phrase. Is it likely that he actually shot this guy in the foot? No, but I'm going to do my best to explore it. I don't want to assume. And so I explore it, and I said to him, I remember saying, you know, did you shoot him in the foot in real life, or is that something that you wanted to do, or something else? And he was like, oh, yeah, I wanted to shoot him in the foot. And so then I had the opportunity to go back and clarify even further. So, did you shoot him in the foot? And he's like, no, I didn't shoot him in the foot, but I wanted to. Tell me all about wanting to shoot Mr. So and so in the foot. And so he talks about then his feelings surrounding it. Like, I was really angry with him, I was upset, and I wanted to do this because I wanted to get away. That's a beautiful opportunity as an interviewer to have that child go into those types of details for court purposes. That is only going to lend to the credibility and the validity of that child's statement on stand. And so we can actually start prepping for court in our interviews before we ever actually make it to the stand and being that expert witness. And part of that expertise is gathering those specific sensory details in our actual interview room. And so he was in that tentative phase. And then as we were able to clarify and kind of process through what was happening with the gun situation, we were able to get back into an active disclosure where he was like, okay, but yes, he did touch me, and gather some details around that. Now, for all of you interviewers wondering, did I go on to further explore about the gun and whether or not guns were used in their home? And if there had ever, I did. I went back and explored all of that, I promise. And then, of course, active disclosure, I don't need to go into that. That is when the kid is giving us those details. But I do want to take a moment to stop about just reiterating that piece of just because a child is an active disclosure, so they're giving us information about what happened to them, it is impossible for a child to give us every single detail that ever happened to them. And a lot of times, when I teach interviewers, I use the analogy of going to the grocery store because that's something that all of us do regularly. Like, we have to have food. Though some of you may avoid the grocery store now and just order DoorDash or delivery. But even in your process of ordering delivery or DoorDash, you have a routine of what you do, right? A routine of, like, I know when I go to Target in my area, I'm going to walk in the door and I'm going to continue to go straight. And then I may take a right at the ends, right? I have like a standard routine of how I grocery shop or how I shop for things at certain stores. And so oftentimes I'll throw it back to those that I'm working with to say, well, tell me all about the last time that you went to the grocery store. I want to know literally everything that you did from beginning, middle to end. And oftentimes what happens is they fall into a script versus an episode. And we'll talk about episodic versus script memory. If you've done any forensic interview training, I know you know about this already, but it's such an important part when we're looking at active disclosure, because a lot of times people say, oh, active disclosure. And this is absolutely what defense is going to say on stand. Oh, active disclosure, then the kid told you everything, right? And my response always has to be, it's impossible for a kid to tell me everything that's ever happened to them. Just like if I asked you to tell me all about going to the grocery store and every time that you ever went to the grocery store, you would leave out details because you don't remember all of those things. And that doesn't make your disclosure invalid. It doesn't mean that the information that you're sharing is wrong. It just means it's impossible for you to remember everything. And it's also impossible for us, the interviewer, to gather every single detail that there ever could have been. Of course, in interviews, we can hear language that suggests that the child's recanting. So I lied because I was mad. I lied because I was upset. Um, I hear those languages all the time. It's an opportunity again for us as interviewers to explore where that comment is coming from, or why the child is saying that. And then, of course, moving back into that reaffirmation. So I'll share another brief case situation that I think would be super helpful here. I interviewed a child. She would have been 13, 14 at the time. When I interviewed her, she had recently had a baby, and that is why I was interviewing her. There was allegations that her adoptive father had been sexually assaulting her and that she had gotten pregnant with his child. And she came in, did her interview with me, had her baby with her at the CAC, and actively denied all allegations of abuse or neglect. Went on to tell me about how she had gotten pregnant essentially from a one-time situation with a fellow student. She couldn't remember that student's name. She couldn't remember how she met that student. That student was no longer at her school, could give me zero information about the student that she had allegedly had sexual intercourse with. And so, unfortunately, we were pretty early on in this case, and her two siblings were also actively denying any information. And so, we really, as a team, kind of had come to the standpoint of there's not much else we can do to move forward. And move forward about 7 months later, I got a new report on the same child and same allegations. And we staffed it with our district attorney's office to say, where are we at here? This was before they had started teaching about follow up interviews and expanded interviews and all of the different formats that we could do interviewing in. And so I was like, gosh, I don't want to push the line here. I know we kind of, again, this was the time where they were saying one interview, one and done. You can't do multiple interviews. And after discussing it with our district attorney, we agreed that it was a new allegation and that she had had continued access to the adoptive father because they still lived in the home together. And so we opted to have another interview, but with very strict guidelines of this was not an attempt to rehash what was, alleged 6, 7 months ago. It was just a, hey, what's been going on? Is there anything new or different that we haven't talked about? And so she came in and did her interview with me. And from the very beginning of the interview, she moved from denial all the way to reaffirmation and said, "Yeah, I told you that my kid was some random guy that I had slept with. That's not true. I've never slept with a random guy. It's actually my adopted dad's baby." And so we had this opportunity in the interview to really talk about, um, you know, why it was okay to tell me that now versus 6, 7 months ago when you came to see me and you shared that that was the opposite. And she talked again about how she was really scared and how, unbeknownst to all of us, the night before her interview, her mother had slapped her in the face and told her, like, if you share that with anybody, if you say that about your dad, like, you can't live here anymore and you're going to be in trouble. And so, of course, those influences happened. And so we then were able to talk about, well, what's new now? What made it safe and okay for you to share now? And so these are some instances where I've seen all of these pan out in the middle of my interview. And when they're panning out, I said to myself, gosh, how do I deal with that? And the first thing that I said to myself is, if how am I going to deal with it is I've got to consider the influences. And this is kind of like pre-interview work that I do. When I'm looking at a child's case that I know I'm going to be interviewing, I'm considering all of these factors that you see before me. What's the child's relationship to this alleged offender? Um, Absolutely, if kids love their offender, are close with their offender, that can make things look so different in those stages of disclosure. And I think we would be ill-informed to not consider that relationships of the alleged offender to the child that we're working with is important. Children absolutely still love their moms, their dads, their aunts, their uncles, their grandparents, their mommy's best friends. They still love those people, even though they did allegedly something bad to that child, right? And so we have to keep that in mind because their relationship to the offender absolutely plays in how they do or do not disclose information. Of course, we've got to consider developmental factors. We work a lot with children who have different abilities and different developmental levels. And I'm sure you guys do too. I absolutely encourage you to continue doing trainings that would focus on those developmental levels because it is so helpful. Um, but keeping that in mind as you go, are there accommodations that need to happen in your interview because of this influence that's going to happen? The other part that I think we don't talk about a lot when it comes to developmental factors is the development of the caregiver, not just the child, but the caregiver that's going to be transporting the child for their forensic interview or for services at the CAC. What's that parent's developmental level at? Because that can also impact literally this entire list of influences. Other things that we would absolutely consider is family beliefs, whether that's religious beliefs, cultural beliefs, just like impact of the environmental beliefs around them. For instance, I live in the Bible Belt. So I told you guys I'm from Mississippi. We live in the Bible Belt. There's a lot of churches here. Frankly, within just the 4 mile radius around my office, there's about 22 churches. So heavy on the Bible Belt. It is not uncommon for me to see children who have concerns that they're no longer a virgin because of something that happened to their body, or concerns that they're going to get shunned or banned from their religion, their church, their temple, whatever that may look like because of something that has happened. That will absolutely impact their ability to disclose, how they will disclose, and the stage that they're going to fall in. And then, of course, considering that in some cultures, there's behaviors that happen that we, in our area may consider abusive, but their culture would not consider it abusive. And so I'll give you a brief example of that. We actually have a very high Hispanic population in my area, and we were working with a family that speaks Hmong only, which is actually a dying language. And they were using a punishment technique with their 4-year-old, where they were pouring hot sauce and forcing the child to eat peppers as the punishment. And so our team had just a very interesting time of like trying to work through this case and recognizing some cultural pieces there that we weren't super familiar with. And so just again, some considerations to that. Obviously, the level of support from the child's caregiver, the child's friends, their community, how people are responding to this child's disclosure or their lack of disclosure or their recantation or reaffirmation will absolutely impact your interview and how that child is responding. It's oftentimes why we teach in forensic interview protocol training, regardless of which training you've gone through. We teach assessing for coaching, assessing for conversations that have happened surrounding what's going on in that child's life. And then I separate reaction to disclosure and level of support because I see these as two very different things. Caregivers can absolutely have a poor reaction to disclosure, but then circle back and have an appropriate amount of support, and vice versa. They can respond appropriately to disclosure, and then their level of support can plummet in a heartbeat. And so I like to keep these as two very different influencing factors. We all know that when a child makes an initial disclosure or there's an accidental disclosure and something is found out, information is revealed, that act is happening of revealing, how we respond to it can have a lasting impact. We know this. Responding positively with support and care and love can empower children, and responding with fear or shame or embarrassment can shut children down. And so I want to give some consideration to when this child made a disclosure or the accidental disclosure was made, how did the people around them respond? Because that will be beneficial to me as the interviewer in the space. Like, how am I approaching? What's the language I'm using? But not just my verbal language, my body language, right? And then that's a good piece to be able to explain in court, like when I'm speaking with a jury. Hey, not, and maybe not necessarily me, but people on our team to be able to talk through that whole case process of like, this was the initiation, like the child discloses here, or the accidental disclosure happened at this time, and here's how people responded. And then from the educational side of it, as an expert, I can speak to the research behind how that impacts children, and you guys can do that too. And then, of course, looking at continued access to the alleged offender. So looking at that from two ways, not just the proximity, not just the physical space between the alleged offender and the child or person that we're working with, but also the emotional connection and access. I worked with a young girl once who it was her uncle who was allegedly sexually assaulting her. And in return, she received gifts of being able to, like PS4 gifts. They played these different video games and things like that together, to the point that the child, she was like 9 or 10, would actually actively seek out her uncle for sexual play and time, because she knew in return that he would let her play the PS4. And so even once she was removed from the home, placed into a safety plan and things like that, the emotional connection that she had with her uncle was extremely strong, and she was very hesitant to say things about her uncle that she perceived would either be negative or get her uncle in trouble. So again, just an influencing factor we want to look at. And then I feel like the really obvious one is fear of what's going to happen next, whether that's intended consequences or unintended consequences. I think we forget that opening up a case and an investigation on a child and their life is such a big impact. And man, so many things happen all in one instance at that point. And sometimes big changes can happen that the child may feel like this is a punishment for me saying something, right? Or I feel like, it's really unfair. I get this a lot with kids who have to change schools because of something that happens, or they have to change sports or their extracurricular. They feel like they've lost something fun in the process or something good in the process, and it feels really unfair. Um, or even in instances where I've had children who have initiated on other children, and they then can no longer play together. And it's like, well, now the non initiating child misses that person and is like, man, I don't get to spend time with them. It feels like a punishment. So just being mindful of these influencing factors before you walk into an interview room, super helpful in how you respond and how you can slow down in your actual interview space. And that's kind of where I go back to now what? Like you've got this kid in the interview with you and you're hearing those different phrases, whether it's the denial stage or the active or the tentative or recanting or reaffirmation, you're hearing those key phrases. And again, they can be different phrases than what I've offered you all today. I know you're thinking about ones that you've already heard yourself. When we hear those, how do we respond in a way that we are putting that child first in our space? I feel like it's obvious, but I want to make sure I'm super clear when I talk about combating the different stages of disclosure in a forensic interview. I hope that you know I am never saying that we should push kids into a disclosure, and I definitely do not think that that is the purpose of a forensic interview. I stand very firmly that the purpose of a forensic interview is to offer that child a safe space to share any experience that they may or may not have had, and for us to be able to do a full assessment of anything that may or may not have happened to them. But with that, I also know that if a child is making a disclosure or even popping up some red flags in our interview, we have to be able to combat that, right? Like we have to be able to respond to that. And so, my first and foremost feedback anytime we run into anything that looks like a block in our interview, um, is know your protocol. Know your protocol. It's the easiest one, but your protocol is your fallback. Man, it's your fallback. It's what we sit back on because so I'm trained in child first protocol. I know some of you are probably trained in some other modalities like NCAC or in ICHD, but they're all similar in nature. And ultimately, our protocol gives us the opportunity to follow the child, right? Your protocol probably tells you some language like this. The protocol's flexible, right? You have some phases of the protocol, but it's flexible because you should be following the child and letting them lead the interview. And so if I find myself in a situation where a block like that, like blocks in the stages of disclosure pop up for me, the first thing that I'm going to do is say, what does my protocol say? I'm going to fall back on my protocol every single time. So it's so important whether you are a beginner interviewer or you have been interviewing for 25 plus years. Know your protocol in and out and recognize that protocol is ever changing because best practice is changing, right? And so make sure that your protocol is giving you their updates regularly. Attend refresher courses so that you are so familiar with your protocol that you can talk about it backwards and forwards. It is like second nature to you to spill that information back because it will become your crutch in an interview when a block pops up. Of course, listen for those common phrases because that's when your protocol is going to be helpful to you. And then gather the sensory details. Gather those sensory details. I think forensic interviewers, oftentimes, especially when we're new to the interviewing world, we are so focused on making sure that we answer every question that the protocol says we're supposed to answer, right? We're like, did I build rapport? Did I do my narrative event practice? Did I transition into family appropriately or transition into the topic of concern or, whatever language it is that your phases look like. I think we get so focused on that we forget that this is actually a conversation. And yes, we're trained professionals in this conversation, but it is just that it's a conversation between you and this person or this child about anything that may or may not have happened to them. And so I want to understand all of the surrounding pieces there, because when the child starts to move in and out of those stages of disclosure, it is so helpful for a jury to see the details that help corroborate and add some validity and credibility to that child's statement. So gathering the sensory details is super helpful for combating that. Of course, depending on your protocol and what interview tools look like for you, I encourage you to use them. So we use diagrams and dolls regularly in my area. They are super beneficial and they can be helpful depending on the stage that the child is in. If you're going to use those tools, obviously use them appropriately to your protocol. So for instance, in Child First protocol, dolls would not be pulled out unless the child has already made a disclosure in the space. So just be mindful of those like rules that you have to follow, and be mindful of the research that backs you on using those tools. People get really scared and a little squirrely when we talk about diagrams and dolls, but hear me when I say when used appropriately, they are effective. But that is the key. They have to be used appropriately. And I'll be sharing some research with you guys today that talks about using diagrams and dolls appropriately. And then, of course, you heard me talk about the episodic versus the script memory. A lot of times when children are bouncing back and forth between stages of disclosure, it is not because they are reluctant. It is not because, or let me correct that. It's not because they're rebellious. They are reluctant. It's not because they're rebellious. It's not because they're defiant. It's not because the abuse didn't really occur. And it's not because they're just hoping to make your life miserable for the day. I promise you, it's not all of those things. Even though there have been times where I've been in an interview with a kid and I thought, this kid is out to get me. But that's not true, I promise. Um, they're reluctant, but they're reluctant for a reason. And when we can pull that episodic versus script memory for them, oftentimes we can see that reluctancy kind of release. So, a lot of times, what I look for is qualifiers. This is what I call them. And it's just words that kids use that tell me, hey, we're moving from a script into an episode, or we're moving from an episode into a script. Words like always, never, sometimes, that tells me that the kid is talking in script. And that may be because they're reluctant. It may be because they're uncomfortable sharing mass amounts of information about themselves. And so they're like, let me give this generic information. It's our job to bring them out of that script and into an episode. I often describe this, again, I've used the grocery store analogy, but I also really like to use the analogy of our favorite TV show. I'm a huge Friends fan. I love the TV show Friends. I've watched it for a really long time now, and I can tell you all about the script of Friends, all 10 seasons of it. I could give you a script of what happens, but I could also tell you about my very favorite episode of Friends and the details, the step by step of what happened in that one particular episode. I feel like sometimes when we break it down like that, it's helpful to understand. And so really, if you take anything away from the webinar today, what I really hope that you take away is reluctancy is not equal to rebellion or defiance. It's really not. And I invite you to take a second right now to just think about a time that you were reluctant to do something or to say something. You were reluctant. Think about why you were reluctant. Maybe it was fear of how other people would respond. Maybe you were reluctant because you felt like you'd already done a lot to do or say something and it was negated before. And so you're like, why would I continue to say it or do something about it now? Maybe you were reluctant because you thought you were going to get in trouble. There's so many reasons why we're reluctant, even as adults. Um, uh, I'm going to tattle on myself. My husband does know, I told him already, but the other day I took my brand new car. Okay. I say brand new, it's used, but it's brand new to me. I took my used car and I went to park into my garage, and he's always telling me, Riley, you drive way too fast into our garage, girl, slow down. And I didn't. And so when I parked into my garage, my brand new car, I hit we have a wooden shelf built in our garage to hold things, and I hit it and I put a scratch on my bumper. I did do that. And so I immediately was like, oh no, how do I fix this? I'm in front of my bumper. My kid is in the back who's like, Mommy, what did you do? And I'm like, cut it, don't say anything, right? And I'm, panicking because I've just hit my car into this wooden thing. And I was like, okay, gosh, I need to tell my husband, but I really don't want to. I was reluctant, not because I thought anything bad was going to happen, but because I was embarrassed. And I felt so guilty because I just bought it like 2 months ago and now I've ran it into this wooden shelf. So when I sit and think about just the amount of reluctancy that I had in telling my husband, who I know is a safe person, who is always kind to me and has never responded poorly to me, but my own feelings of embarrassment and shame and like kind of guilty because I just bought this popped up for me. If I take that and apply it to a kid who's like looking at life situations of things that have happened to them, that people have harmed them or hurt them, gosh, I absolutely expect them to be reluctant. And that's not because they're rebellious. It's not because they're out to make my life miserable. It is simply because when life events happen, our feelings pop up, right? They get in the way. And unfortunately, children don't always have that same response that I know how I have in my space of somebody who's going to be supportive and loving of me and very forgiving of an accidental situation, right? So I hope that you guys think about that and take that away from here. Okay, I have said a whole lot about the interview room and process of disclosure, but how do we take that from the room and put it on the stand? How does that make us experts and how do we present that way? Well, first and foremost, I think there's a lot of prep work that has to happen well before we ever go into the room, well before we ever get on stand, and well before we ever receive that subpoena. And that first one is making sure that we have appropriate documentation about why we are an expert. And that is exactly what your CV is. Your CV is the documentation for why you are an expert. And so this is not an exhaustive list. Please hear me say that. This is a list of things that I think you should at bare minimum have ready to go on your CV at all times. And making sure that any information you have on your CV, it speaks directly to the credibility and the reason why you are considered an expert. And if it's not doing that, then I want you to consider what's its purpose on my CV. I really live by this "what's my purpose" piece because we live by it in the forensic interview world. If I'm going to do something in a forensic interview, I always ask myself, what's my purpose? And if I don't have a purpose, or my purpose is to elicit a disclosure, then it's not my purpose, right? I feel the same way about my CV. My CV has purpose, and it's to show that I am credible as the expert that I say I am. And so if the information that I've put on my CV does not directly relate back to my credibility, then I've got to weigh what's my purpose, right? So making sure that first and foremost. So there's the basics, right? Your educational experience, your employment. Oftentimes when you're at the level of like you're putting yourself in on a CV, I ask a lot of the interviewers in my space and those that I provide peer support to and supervision to take off any employment experience that is not relevant. So I'll give a really good case example. Previously, even though I do all of these other jobs, one of the other jobs that I used to do was just nursery coordinator at a local church where I just set schedules and plans for volunteers to take care of kids. That is not relevant to my role or my credibility as far as an interviewer and working with children who have experienced trauma or may not have experienced trauma, right? That's just relevant to my organization skills. And so I take that one off. It's not important for my CV. Uh, I also want to give some consideration to number of interviews. So there's some back and forth on this. You may have heard some presenters say you should always include an approximate number of the interviews that you've conducted in your time as an interviewer. And then I have some other interviewers who will say, no, you don't include this. What I will tell you from a CV perspective is I would check with your district attorney. So in my area, I used to provide on my CV an approximate number of interviews that I've completed, and I will tell you if you're going to provide an approximate number, lowball it. Um, I would never put anything higher than so. Like if my number of interviews I've conducted to date is like 1,500 interviews, then I'm going to say approximately 14 to 1,500 interviews, right? I give an approximate number because what I don't want to do is have a defense attorney who's going to suggest that I lied about the number of interviews I did to sound better or more experienced, right? But if you talk to your district attorney, which I highly encourage, and you'll see that as we go through, When I talk to my district attorney, things that I give considerations for is what do they want on my CV. My district attorney says do not put a number of interviews that you've completed, and instead just be prepared to answer that question in court versus putting a number on the CV, because sometimes in my jurisdiction, it may look different in yours, but in my jurisdiction, they'll ask for my CV 2-3 months back. And then I actually go to trial 2-3 months later, and they're using the CV that I had 2 to 3 months before that. And I've updated my CV since then, right? And they may not have that. And so being prepared to not have any finite numbers that can be questioned. But again, talk to your district attorney about that. Some district attorneys are totally fine with that approximate number. I'd say check with your district attorneys, check with the area that you're in, and what's the common practice that they're suggesting. Definitely provide the number of trainings you attended and the number of trainings you've conducted. You guys are experts. So if you've conducted trainings, if you've given presentations, if you speak at conferences, that speaks to your credibility, your expertise. Put it on there. I put every single training that I attend and every single training that I've conducted that is related to my role in my job and my expertise. And I've seen people who do this in two different ways. They can include it on just their general CV, or they'll do a supplemental. So it's like, here's your CV with your base information. And then like, here's the chart for all the interviews, or here's the chart for all the trainings that I've attended. Here's the chart for all the trainings that I've conducted with like brief explanations of each. Either one of those is totally fine. Make it work for you, but definitely include that information. Other things that I might would consider is whether or not you do peer support facilitation. Guys, I know that as an interviewer, it is very rare that the only hat that you wear is that you're an interviewer. I know you guys are doing more than that because I know I'm doing more than that, right? And so I'm an interviewer, but I also facilitate peer support for my state. So that means I'm actively going to other interviewers and offering them support and supervision and feedback on their interviews. I include every single peer support facilitation I facilitate, as well as any peer support that I go to as just an attendee on my CV. Of course, if you've attended court, any court, so Chancery Court, Youth Court, Circuit Court, if you've had to go to court and testify because of your role, absolutely include that. Absolutely include that. And I would include as far as like what court I was in, what was the jurisdiction, what was I testifying about? So did I testify as an expert or did I testify as a lay witness? So that they can see those pieces. And then any special appointments you have. So for instance, I'm appointed by the governor to our Children's Justice Act task force. I include that appointment again to speak to my credibility and expertise in this field. Here's the obvious one, regularly update your CV, right? Your CV should be updated. I update mine every couple of weeks. It's just a running working document for me. So like for instance, when I finish here today, this will absolutely go on my CV and it'll just be a little nugget that I add to it because it's relevant to my credibility and my expertise. The other thing that I would say outside of your CV is knowing your research. And this one's a little harder because it takes time. It takes time to read articles. It takes time to really immerse yourself in this. But have some considerations for the research that you have. If you've gone through the forensic interview training, no matter what modality you've gone through or protocol that you've gone through, I can assure you the training manual that they gave you comes with a whole lot of research in it. You can start with that research. I know if you're child first interview trained, there's a whole packet of it in the back that covers all of these topics that I have listed here and then some. And again, not an exhaustive list. If you see this list and you're like, hey, but what about this, Riley? Yes. If you're asking me if you should know about it for court, my answer is yes. Know about it. Include it. Some people will do this in a big binder. I know one of the interviewers, she's no longer interviews, actually, she works for Guardify now. One of the interviewers that I've worked with before, she keeps a full binder of all of this research. It's easily accessible. She knows where it is. She's constantly looking in it and updating it. If hardcore paper is not for you, if you're a tech person, have a folder with all of this information in it. Just be prepared with that research. These are some of those recommended articles. Again, there are so many articles out there. These are just some that I have very specifically used in court before. If you, a lot of this is included in forensic protocol, like forensic interview protocol training already. I know for sure Sorensen and Snow is. Everson and Bode is absolutely included in the child first training, and so is the OJJ DP piece. And I don't remember if the APSAC one is included in the child first training, but again, these are all a quick Google search away. They're all free, and you can find them very easily if you don't have them already. Also, you feel free to reach out to your kind of like your chapter, whether it's your state chapter for CACs or your chapter for the protocol that you follow. So, for instance, Child First, we would direct that back to Zero Abuse Project. They want to help you guys. They want to give you as much information, and they will do research with you, but they'll also do court prep with you, which is really nice. And then, of course, there is our personal prep. This is like, okay, I have my CV, I know my research, and now I just want to be knowledgeable on the basics, right? I ask you to consider your learning style here. I know that sounds really educational and very like grade school, and I mean it too. I mean it to sound grade school because when we were in grade school and when we were in college, people didn't teach us how to study. It was like, hey, here's the information, you should know it and do it. And I think we've oftentimes forgotten that people have never learned how to study material. And I always want my interviewers to be best prepared, and maybe they don't learn the same way that I learn. And so, know your learning style and then adapt your material to the learning style, whether that's a visual learning style, auditory, maybe you're hands on. I have a couple of interviewers in my office who are a see it and then do it. So, they want to see me put it into practice and then they want to be able to mimic that or mirror that behavior. That's totally fine. I'll put my husband on the spot again. My best learning style is being able to teach other people something, because it makes me feel empowered that I was able to teach that to him. And so my husband is often my guinea pig. And I really put him on the spot and I'm like, hey, what's this or what's that? And he's like, I don't know. And I'm like, right, you don't know. So let me tell it to you. And it just makes me feel really good that I can like teach him this information. So learn your learning style. You can do role plays, you can make flashcards, but do it so that you know this information, because the other part of it is if you're actively practicing it, and I know you all heard this, practice makes perfect. It's so true. I hate it sometimes because sometimes I don't want to practice, but it is true. Practice does make perfect. And when we practice, whether it's practicing with our brains or practicing with our bodies, it becomes muscle memory. And if it's not muscle memory, then we will not respond on stand with our best. We just won't. Because when you get on stand, what's going to happen? You're going to get anxious. You're going to get nervous. For me, I start to sweat. I got a fan a little bit. Um, and that's normal. People experience those different things on stand. And so if we're nervous on stand, I know the kiddo's nervous, I know their caregiver's nervous, and they deserve that I do my very best, right? And so I want to make this muscle memory so that when I'm on stand and I'm feeling all the nerves don't block out what my body and my brain already know, which is, what is a forensic interview? What does it mean to be an interviewer? What protocol do I follow and why do I follow that protocol? Being able to walk through those phases and also know the difference between the protocol that I follow and the protocol that other people may follow. In the state of Mississippi, all CACs are required to follow Child First Protocol. It's our mandate. But my sister states, Louisiana and Alabama, follow different protocols. And some of the states that follow different protocols, they follow multiple protocols. So I want to be knowledgeable on those as well. Be able to talk about sensory details and peripheral details, remembering that sensory is your five senses, but periphery details are the WH questions, the who, the what, the when, the where, the whys, right? And be able to talk about episodic versus script, be knowledgeable on what grooming looks like. I'm sure you guys are thinking of some other options while we're talking right now. Be knowledgeable on those. That's your personal prep. This is what you're going to do on your own before you head to court. And then, of course, once you get that subpoena and you know you're going to court, you're going to want to rewatch that interview. I know it stinks to rewatch our interviews. If you're me, you're like, oh, do I sound super country in this one? How's my outfit? Right? But also rewatch your interview. Know what you did well and know what you didn't do well, and be prepared to talk about that, right? So note any of your imperfections to your district attorney. They can help you combat that. And sometimes combating imperfections in our interviews literally just means owning that we didn't do it right. No such thing as a perfect interview. You guys know this, I know this. There's never an interview that I don't walk away from that I'm like, man, I should have asked that differently. Oh, I could have said this. Oh, I didn't provide this instruction here and I should have. Because we're not perfect, right? We're humans, we're flawed. It's going to happen. But if I can call it out from the beginning and hash that out with my district attorney, I'm more likely to be able to combat that on stand or be able to take full ownership of it. That's just the truth, especially when I've been interviewing as long as I have. Some of you have probably interviewed longer than me, and you all know the criminal justice process is slow. I have cases that I interviewed 5 years ago that are just now going to trial. And guess what? Practice has changed since then. And I've done some things in those interviews that now I'm looking back and I'm like, oh, practice has changed. I would have never done that now. And I've got to own that on stand. But I talk through that with my district attorney. Here's my shameless plug for Guardify. They have not asked me to do this, so it's unsolicited. But I happen to also be a Guardify user at my CAC, and I encourage interviewers to transcribe their interviews and mark important portions of their interviews. You can do that easily through Guardify. They have a little, and Guardify can explain this to you better than me, but they have little options inside the system that you can do that with. Like you can pull up the video and you can say, oh, here's where I'm doing process, or this is where I'm talking about disclosure, or this is where the kid switches in process of disclosure. This is where I'm exploring details. Hey, this is where a block came up and I had to battle that, right? That's my shameless plug for them. If you're not using Guardify, I think it's awesome. I'd gladly talk to you about it, but I'll move on. And then there's team preparation. So I have just shared a whole lot of personal preparation that you have to do before you ever make it onto the stand. But there's also preparation that should 100% be happening with your team. And so a lot of times I'll get interviewers who say, well, Riley, I did all of this prep, but I still didn't feel prepared to get on the stand. And I'll ask, well, did you talk with your district attorney? Did you meet with your team about this case? And they'll say, well, my district attorney didn't have time to meet before trial. So let me back you up and say, advocate for yourself. If you are having a hard time doing team preparation, go well in advance before there's a subpoena and talk to your district attorneys about how important team preparation is. I do not like to get on stand and testify, no matter how good my interview was. I do not like to get on stand and testify when I haven't had the opportunity to meet with my team about the case that we're about to go on stand and talk about. That team preparation is so important, and your personal preparation should not replace team preparation, and vice versa. Team preparation should not replace your personal preparation. They go hand in hand. Those are together and should always be together. So meet with your district attorney and your team in advance. I like to meet with all of the people on the team who are going to be testifying in court. So I want to meet with the law enforcement officer, the CPS worker, the district attorney. I want us to have a group meeting and our individual prep sessions. That's how I like to do it, and it has worked best for me. So I recommend it to you guys too. Have a list of standard questions. I'm actually going to be, I have provided the list of standard questions that I use to Guardify. You'll get an email with that list of questions when we're done here today. But I keep that list of questions and give it to my district attorney to say, hey, here are some questions that you may want to ask me on stand. And it'll even give some language options on how to ask it to get the best response from me. Because we often teach that on stand as expert witnesses, we respond with yes, no when it's a yes, no question, right? You guys know this from interviewing. Yes, no questions elicit yes, no responses, right? And so I'll encourage my district attorney to ask some more open-ended questions to get the response that they're looking for. And then, of course, discuss with your district attorney what are some common defense questions that are about to come my way. Here's some of the common defense questions that I see when I go on stand. Truth versus lie. In the state of Mississippi, we are not required to do a truth lie test in the forensic interview. We're actually discouraged from doing it based off of research, but your state may require that you do it. So be prepared to answer questions around that. Defense attorneys love to ask me if the child was telling me the truth. My standard response to that is, I'm not a lie detector test. So your guess is as good as mine, right? I'm not a lie detector test. It's not my job to determine whether or not the child was being truthful or telling a lie. My job was to allow the child a safe space to share any experience that they may or may not have had. Um, if you're working at a CAC, I get this a lot. Oh, you work at a child advocacy center, so you must advocate for children. So I have to combat that a lot. Actually, my job at the CAC is not about advocating. My job at the CAC is more neutral. So I talk about my role. This is helpful to me, especially previously before I was the director of programs. That was super helpful for me because I only held one role. I was a forensic interviewer. I wasn't an interviewer and an advocate or an interviewer and a clinician. It's a little different now because I am the director of programs. So I often have to step in if like staff are out. I may be an interviewer for the day. I may be an advocate for the day. I may be a clinician for the day because I have the accolades to do all of those things. But then I'm prepared to talk about my role with that specific case and to show that there was no crossing on my role. I love this question. Do children lie? Yes, of course. I want you to notice that I use that language of course here, and that's intentionally. I say yes, of course, because I have an unwritten rule with my district attorney that if I use big language like of course, that means, hey, you need to follow up with me on redirect. I said yes, of course, because it was such a ridiculous question that I also have some research to back why I would say that. So anytime I get asked on stand, do children lie? I say yes, of course they do. And then my district attorney comes back and says, Riley, I heard you say, of course children lie. Expand on that for me. And then I get to say, yeah, everyone lies. We know that. But here's the research that suggests that just because a child knows how to lie or can lie does not mean that they are telling a lie when it comes to this disclosure, right? And we can talk about their pattern of behavior and their pattern of lying. There's no suggestion that they lied to me throughout the interview when they talked about going to the water park with their mom. Mom confirmed they did, in fact, go to the water park, right? I can show throughout the interview where the child was truthful and suggest that, again, lying did not occur without having to say, this kid did not lie to me. Understanding that forensic interview is a science, but it's not a hard science, it's a soft science, and being able to talk about that. And I love this question too. I get asked a lot, do you ever testify for the defense, or why have you not testified for the defense? Well, because the defense has never subpoenaed me and I can't help that, right? So I can respond with that. I can talk about that. And then I'll briefly share about this because I know I'm running out of time, but I just have so much I want to say. Um, a lot of times on stand, I'll get questions like, well, you just believe all children who come to the CAC have been abused. And that's not true. But there have been times where I have done news articles, I've spoken to the news live, I've written my own stuff, I post things on social media. I'm sure you guys do too. And it's so important that we keep those things private. So my social media stays pretty private these days. And it is because there was actually a news story that I had done that was clipped. So it did not give my whole statement, where I had said the children that are coming to us have already experienced some sort of trauma. Oh gosh, and the defense had a field day with it. They took that clip of children have already experienced some form of trauma. And they threw that to me on stand and said, well, isn't it true, Ms. Heron, that you believe that all children who come to the CAC have been traumatized? And I was like, no. And they were like, well, here's this news clip. I'd like to, put that into evidence. And they talked about this news clip. And so then I had to have the opportunity to say, I think it's absolutely fair to assume that all children who have law enforcement and CPS showing up at their door to have conversations with them about things that may or may not have happened to them can be its own form of trauma. So I was able to save it, but I put this one in here to say, be mindful of what you say and how you post that on media, because they can spin it and they will use it. This is my last one. I promise I'm wrapping up. Being mindful that as a forensic interviewer on stand, you are a professional and it is not personal. It's not. I know it's hard to differentiate. I shouldn't say differentiate. I know it's hard to kind of remove yourself sometimes, but we remove ourselves from the forensic interview room and we also have to do it on stand. We have to remain neutral. And remember that our primary role as an expert witness is to educate. Our primary role as an expert witness is to educate the jury, to educate the court, and the professionals within the court. And so when I put my educator hat on, it makes it a lot easier to remove that personal piece because it feels personal when we're on stand and the defense attorney's coming at you with questions left and right. It feels personal, but it's not. I promise it's not. It feels personal. And so when you have that muscle memory and you realize and remember your role as an educator, it's a lot easier to kind of push those personal feelings aside. Let your district attorney do that fighting for you. There's no reason for us to argue with the defense or the district attorney. There's no reason for us to get sassy, though it's hard. I get sassy sometimes, I won't lie, but it's hard. But remove yourself from that side. Let the district attorney do that fighting. And then the last two pieces I'll give you is know your limitations per your state. So there are some exceptions in Mississippi and in Michigan, but I will tell you I even toe the line on that. Mississippi and Michigan will allow interviewers as expert witnesses to say whether or not, in their expert opinion, they believe that this child has experienced some form of abuse. I will not testify to that, even though I'm allowed to in Mississippi. I still push a lot of caution on that. Instead, we testify to things like, in my experience, this child is consistent with other children who have also disclosed experiencing abuse. But I would say talk to your district attorney about that too, and what's the limitations on that. And then lastly, this one sounds silly, but gosh, it's so important. Considerations for your attire. One, remember that you're a professional, so you should be wearing professional attire on stand. That speaks to your credibility just as much as what says or what comes out of your mouth. But also, a lot of times interviewers and professionals in general will say to me, oh yeah, I went and bought a new outfit. I actually discourage buying a new outfit before you go into a stressful situation, because oftentimes you're not comfortable in it. You haven't worn it in, you haven't felt, you don't haven't gotten to a place where you felt confident in it. And so you'll be up there fidgeting and pulling and doing a lot of this. And what that says to the defense and what that says to the prosecution and what that says to the jury and the judge is that you're uncomfortable. And it's okay to be uncomfortable and acknowledge it, but be uncomfortable because of what's actually happening, not uncomfortable because of your clothing choice. So I recommend choosing clothing that you feel best in. And my last little tidbit, wear the color blue. Blue is research backed to be the color of trust. When you wear the color blue, people are just more likely to trust you. Okay, Michael has popped up, so I know that's my time limit. I'm going to pass it back to you, Michael.
Riley, incredible. Thank you so much. This was great stuff. We do have a few questions. What is your experience navigating the court and helping them understand as to why a child may need more than one interview regarding disclosure? For instance, if you do an initial interview and the child doesn't disclose or minimizes, and then maybe goes to therapy, and then the child begins disclosing more information, which then may warrant another interview. How do you explain that into a court setting and worry, and how do you overcome things like that where maybe a case may not be filed because they look at it as another interview? And how do they decide which one is truthful?
Yeah, no, I love that question. Okay, so let me hit on two pieces of that because I think that's a two-part question. Number one, anytime I'm going to be in court and I know that a child has had multiple interviews, I'm going to be prepared to talk about the process of disclosure. So that's the biggest part, is making sure that your jury is educated and the court is educated on, again, disclosure is not linear. It can come in so many forms and kids can go back and forth through that disclosure. But then on top of it, incorporating why process of disclosure would then link me to do multiple interviews and what that looks like within your protocol. So I'm going to speak specifically to child first because that's the modality that I sit in. But we teach your traditional forensic interview, expanded forensic interviews, and follow-up interviews. But each of them have a different definition and a different purpose. So I'm knowledgeable on the definitions behind each of those and why I would use them or what that purpose would be. So in this instance, if I had a child who did a forensic interview, like an initial traditional forensic interview, and maybe they made no disclosure, or maybe they made like a tentative disclosure and there were some red flags that popped up, but it was ultimately inconclusive because there was lacking like detail and peripheral things. Um, and then my team came back and said, oh, Riley, Sally Sue went into therapy and now she's an active disclosure. Then what I'm going to do is, first and foremost, I'm going to pitch it back to my team, which includes my district attorney's office, to say, hey, Sally Sue did this interview with us before. She made no disclosure or she made a tentative disclosure, but it was ultimately inconclusive. But now, because she's a part of the team process, she's sharing more in therapy, and investigators are wanting to gather that information. I'm now going to argue on stand that we did a follow-up interview based off of new information regarding the same allegation. So it's follow-up. It's not another bite at the apple. It's not another opportunity to rehash. It's just there was some new information. Let's talk about the new information and why it's okay to share that information now. I'm going to talk about that in the process of disclosure and child development. And then on top of that, I'm also going to talk about the purpose of a follow-up interview and new research that is shared with us in protocol about why a child may need more than one interview and why that is no longer best practice. That's my really quick answer. I hope that helped.
That was fantastic, fantastic. Thank you so much. Riley, you gave also some really great advice on the reluctance and one thing to take away from your webinar, but there was so much to take away from. If you were to give some advice to someone who's going to testify for the first time in their first deposition, what would you say to them?
Yeah, if you're going to testify for the very first time, I cannot overemphasize the need to prep individually and with your team. I don't recommend testifying for the first time without that prep. So do your prep work on your own, but absolutely go ahead and set up time now to meet with the attorney, to meet with your district attorney and express your concerns, express what you think went well and what didn't go well, and most importantly, own with your district attorney that you're nervous. Own it. Say, I am nervous. I'm freaking out. I need all the support I can get. Because one of the things that my district attorney will also do for me is when I get on stand and they know I'm nervous, I get nervous every time I testify. And I've testified a good bit, but I get nervous every time. And my district attorney will say, hey, Riley, how are you feeling today? And I'll just own it on stand in front of everybody because I'm human. I'll say, gosh, I'm feeling a little nervous about being here today and being in the hot seat. And then I can say, and I feel like, probably the other people that I've had to get up here feel the same way. So I'm making it normal. I'm normalizing that I'm nervous, and so is everybody else that gets on here, including the kid, right?
Absolutely. Thank you so much. There's still a ton of questions. There's going to be a lot of emails to go out to help answer some of these stuff. You did touch on your CV a little bit, kind of a two-parter. Would you be comfortable sharing that CV so people have an idea of what that structure looks like? And of all the things you mentioned putting on there, would you recommend putting research or journals actually on your CV, or how would you handle that situation for court?
Yeah, absolutely happy to share my CV. I assume I can just push it through the Guardify team and they'll kind of disseminate that for you guys. Happy to share that. I would say take my CV and make it your own. It doesn't mean that my CV is the best CV out there. And frankly, if you look at my CV and you have any recommendations, I'll take them. But as far as including research on your CV, I only include research on my CV that I have personally had a hand in writing or helping do the research on. I wouldn't just like put other articles that other people have written on my CV, because if you do that, then you obviously need to be prepared to speak to that. Instead, I'm not doing the defense attorney's work for them. If the defense attorney wants to reference any type of research or materials or articles, then they're going to come up with that on their own and I will speak to it. And that brings up a good point of if the defense attorney or any attorney brings up an article that I'm not familiar with, then I'm going to own that I'm not familiar with it. And that I would love to take some time to look at it, but I'm not going to speak to something that I'm not familiar with.
Awesome. Thank you so much, Riley. It looks like we are reaching the end of our time today. I want to thank everyone for coming to the webinar who can make it. Thank you so much for Riley for a wonderful presentation. Please look out for an email later this afternoon that will explain how you can complete the evaluation form, receive your certificate of attendance, and Riley's contact information. We have tons of questions. We're still going to try to get those out for y'all. Thank everyone so much for being here today. We truly appreciate it.
Thank you guys so much.